don't need to hear that. Whether or not you had justification for seeking the PPO isn't even on the table today. The truth or untruth of what Ms. Moisisian said is not important right now. What's important is she's letting you know that she wants to include that under 404B.
Yeah, she's just misrepresenting information that's filed upon the court.
Which, once again, according to you. So I'm going to ask one more time, and then I'm not going to let you talk anymore. Talk about on the day of trial?
I'm going to add it all in. She's going to hear it all.
Okay. I just... Sure, we'll do it. Yeah, put it together. Yeah. All right. So she's on notice. I'm on notice. Got it. Anything else as to the motion that's up today? Motions that are up today?
Yes. So in regards to that, that is a direct violation, and it's a cause for dismissal, a swift dismissal, because it's violating me, it's causing terror, and it's 2 or more non-continuous acts as well.
So even if Ms. Green was standing in front of me right now and admitted doing that, that would not be grounds to dismiss this action.
Well, she already lied in regards to the whole entire 6 allegations.
Which,
okay.
You heard what I said, and that had nothing to do with the 404B.
Mm-hmm.
So don't talk anymore, because I've given you 3 opportunities and you haven't taken them. So I'm ready to rule on the pleadings. I'm denying all of your 404B motions because the proof is exactly what we just went through today. Under 403, and I'm going to read it because I think the whole damn thing applies to this case. Although relevant, and we can question whether or not all this stuff would be, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Everything I'm hearing from you is almost all of those things, and most of what I'm hearing from you is just going to confuse the hell out of everybody. So we're going to talk about July 18 to August 10 and January 14, and that's all we're going to talk about on the day of trial. We're not getting into anything past, anything beyond that. That range of dates in that January 14th date is all we're going to hear about when the jury's in the building, which is when? January 29th? All right, now, are you still seeking a court-appointed attorney? Because my understanding is they're just waiting for you to fill out some paperwork before they can process that.
Who is they? I don't know who they is.
MIDC.
Oh.
My understanding is you didn't want to fill out the paperwork Ms. Patton asked you to fill out.
She never asked me to fill out anything.
I sent it to him and he did not fill it out. And that's what they need.
Your name is Ms. Mortsfield, not Ms. Patton. Ms. Patton never gave me anything.
Well, did Ms. Mortsfield send you something about a court-appointed
attorney? Yes, she did.
Did you fill it out?
I did not.
That's why you don't have an attorney. Have a nice day.
I didn't request one.
Goodbye. January 29th, what time we scheduled?
8:30.
8:30. If you're not here at 8:30 on the 29th, I will hold you in contempt, and I'll deal with that after the jury trial.
I'll be here at 7:45.
That'll work.
Please ensure that the defendant is not contacting or included.
So what are you doing now? What's your main function?
So I'm doing mostly all sexual assault cases, but the focus is on the untested kids. So sexual assaults from like the late 1990s, early 2000s.
Oh my God. It's got to be.
Yes, I love doing that.
Really? It seems like it'd be so frustrating.
It's the most frustrating. It's so frustrating, but it's also so much more, I guess, interesting, and the investigators that I have are amazing. That's all they do. It's like their
Yeah.
task force. So
Yeah.
anything you need, they will do it for you.
Yeah, and they're all on the top of their game.
Exactly. Very good officers. Like,
Yeah.
so
Well,
the
I'm glad you're
trials
having
though are
fun.
very difficult because there's so many evidentiary issues
Yeah.
with them.
Yeah.
And then I get mad and then I get annoyed that I'm doing these cases and then I go to trial and then I feel better. And so it's like,
Well, I'm glad you're having fun.
yeah, it's at least I'm learning a lot. Things that I never thought
Good.
I'd do. So yeah. So technically they had tested all of them after a certain point, and then they investigated almost all of them, and now it's just a matter of bringing them forward. We lost like 3 prosecutors that were doing these cases, and now it's just me. And so I essentially, for the last 6 months, was doing all of those trials that they had left, and then now I'm starting to do some of my own, which is nice because I hate taking cases from other people where it's like they've worked on it for like 2-3 years, and then all I do is just go to trial and I know nothing about it, right? The last one I just did last week, I think it was a week and a half ago, it was from pre-COVID, so 2019, but it was a 1998 assault. And so it just, so many delays on different things. Wow. Yeah.
So we've got an attorney, a local attorney here. I've been a friend of mine for 30 plus years. I got to ask him if he's still doing this, but just sole practitioner, right? And for a while, no, that's right. And for a while, does a lot of family law. Does criminal too. You probably met him, Murray Duncan.
Yeah.
Yeah. All right. So he does a lot of family law, and he was just like hired gun because a lot of attorneys take divorce cases, but if they're actually going to trial, they don't want to go to trial. So they just turn the file over to Murray at the last minute and say, "Go try this case." And he told me, he said, "I love it." And I got to back up though. Back as a new attorney, I used to cover stuff for Murray Duncan. So he'd call me and say, "Hey, can you handle a civil pretrial for me in Wayne next Monday?" I'm like, "Sure, Murray, I'll drop off the file." And he'd drop off a folder, and you know what was in it? A copy of the complaint. That was it, right? He's just a pure seat of the pants guy, right? So he's not big on prep.
Yeah.
And back to the divorce trials. And he said, "I love it." He said, because if it tanks at trial, it's because they didn't do a good job with the discovery process.
Yeah.
And if I win, it's because I'm such a great trial attorney. It's a win-win for me.
I wish I could think of it that way because I get more bogged down and like I get frustrated that
you're not a seat of the pants.
Yeah, that people didn't do what they need to,
right.
Especially because I'm so particular with how I do things.
Yeah.
But I mean, that does work. So yeah, I don't know. Sometimes it's like, wow, I can't believe we just pulled this off and it wasn't even my case. And it's like, then you can.
Yeah.
Ready?
Yes.
Okay. All right. So let's because lots of moving targets. My understanding is what we're here to do today is cover both sides 404B motions, correct?
Correct, Judge.
Mr. Phillips?
And
Your Honor, I just have a few concerns. I don't even know if we can even proceed today because there's other issues going on in regards to this case with his interference from the complaining.
You're muffled. I'm sorry.
I have COVID because my son got diagnosed with COVID on Saturday.
Okay, just so you know, that doesn't mean you have it. That means you've been exposed.
No,
go ahead.
I don't feel well, but
go ahead.
But I'll move this closer. So, in regards to this case, Your Honor, the defense is unable to proceed in this matter. There's several issues, substantial and procedural defects in this matter that give rise to a dismissal on the January 14th, as well as the other one, 2201-3499 matter from 7/18.
Okay, you keep referring to the January 14th matter. I don't have a January 14th matter.
Oh, it's the extra information that was amended in the complaint for the same case. January 14th.
I only have one file. That file has a range of dates.
Yeah, the 6th
which
date.
was amended. What are the dates now? We've amended the complaint.
we have, Judge.
What's our window?
I
think it's July something.
It was from July 18th, 2022. For some reason, it's not written correctly, but it should be. And then it just includes July 18th to August 10th and then January 14th because of the request to amend it.
Okay. So there's a range from July 18 to August 10 of 22, and then one day of January 14, 23. It's all one case, all one charge.
It's two complaints, one case.
It's not two complaints. It's an amended complaint to include July 18th through August 10 and January 14th.
Right, one complaint into the court, but the amended date is the January 14th.
I'm just clarifying your language. You said that case. There is only one case that's going to trial.
It's one
It's a
case.
stalking charge. Those incident dates are what the prosecutor's using.
Right, and so
Okay.
I'm referring to January 14th of this year, which will be technically the 6th allegation date in regards to the 2300743 complaint with the police department, not the complaint in the actual court. However, that's added
Okay,
into
get to
this
your point.
complaint.
You're going to make a motion to dismiss?
That is correct.
to your
However, I'm sorry.
Get to your point.
Okay, so in regards to that January 14th, it is known to the court, it is known to the prosecution that that did not occur, and there is police interference in regards to what's going on. police
Okay, your
misconduct,
motion's
and
denied. Your motion's
prosecutorial
denied. That's what
misconduct.
trials are for, Mr.
Okay.
Phillips. I'm not
Okay,
going to dismiss it because you say it doesn't happen.
I didn't say that.
Motion's denied.
Okay,
What's the next thing we have to get to before we do 404B?
very good. So in regards to that, again, I'm requesting Your Honor to recuse itself from the court, as well as this prosecutor recuse herself from this court for this court case, because it's unfair, it's prejudicial.
What's
There
unfair
is
and
pecuniary interest in the
Hold on.
matter,
What's unfair
and
and
we're overlooking
prejudicial?
evidence.
What's unfair and prejudicial?
I'm sorry?
What is unfair and prejudicial about me hearing this case?
Oh, there's multiple events, multiple dates, multiple concerns in regards to this matter. I have
No,
not
wait
been
a
able to
minute,
secure
wait a minute.
evidence.
You can't just talk a bunch of crap. You've asked me to recuse myself because it's unfair for me to hear the case, correct?
That is correct, and I can
Okay.
prepare a motion and an
Okay,
affidavit.
hold on a minute. All right. First of all, this is a jury trial, so I'm not the trier of fact. Second of all, what's unfair about me being the judge on the case?
Oh, well.
Why am I biased? Why do you think I'm biased or I can't be objective? Tell me why I should recuse.
Right, so from start to present date of this matter, where Your Honor has heard the case, again, there's been procedural and substantial defects in this matter in regards to the arraignment. We can start there. The case started 9/30 of 2022. I was arraigned 2/22 of 22. The actual first trial date was scheduled for 2/7. Therefore, it speaks to exculpatory evidence not being heard, Brady violations, even to date, that has not
Okay,
been
once
addressed.
again, you're rambling. What was wrong with the procedure of the arraignment?
Oh, it was not held, as well as
You've never been
the
arraigned,
4 months. There was 4 months from 9/30 to 2/22.
and that was my fault because I'm biased against you. Is that what you're claiming?
It's not my fault,
Well, it's got nothing to do with my bias or non-bias.
but there's, again, multiple.
Do you understand why you can request a recusal?
I
That
do.
there's something personally, there's something that I've got an axe to grind. I can't be fair. There's an appearance of impropriety because you know my ex-girlfriend, or I don't know, but there's got to be some reason why I can't be fair and objective. The fact that you don't like the way we do things doesn't fit.
I
The
didn't say
fact that you
that.
want to control every step of the proceedings and I won't let you and you don't like my rulings, that's not a reason for recusal.
I didn't say
So
that.
unless you can give me something else, I'm going to deny that motion as well.
Well, that's fine, but I didn't say what you said. So other things in regards to the case.
A courtroom clash where control slips fast and authority takes over. One side keeps talking, the other keeps shutting it down. This is what happens when emotion meets strict legal reality.
I've actually, I no longer even do these cases. I'm only on this case because of how complicated it is. And that essentially giving it to another prosecutor would no longer make sense. And so, no, he could write a request to my supervisor and ask that I be removed from this case. I would have no objection to that. It does not matter to me. I don't have a choice. That's not my choice to make. He can make the request to my supervisors and they will make that decision whether or not I should be removed from this case.
She handles the cases they assign to her.
And she's handled this case poorly due to the information that she received.
According to you. And once again, you don't get to control things. You don't pick your prosecutor, just like you don't get to pick your attorney unless you hire that attorney. Move on. We're going to do the 404B now. Is there anything else before we do that?
We can move on.
All right. Anything? Go ahead.
Yes, I do, Judge. Just based on our last hearing when we were here about certain things for me to follow up on. I do have just things that I want to put on the record and share. So I was going through my file with the police reports. One of my statements, or not my, one of the statements I had in my possession from the police that Ms. Green had written was missing the page 2 in my file. I don't know if it was missing the page 2 in his file. So I have the full statement essentially, just in case. I don't know if what technically was uploaded and I downloaded onto mine is what he received.
Understood.
So that's the first thing. The second thing is there were requests for emails from the police between essentially what emails Ms. Green, the complainant, sent to the police department. Those were actually all included in the initial police report. And so I have another copy of the initial police report, and then separately the emails that were attached as supplements for Mr. Phillips. So I have those as well. And then lastly, I requested any of the supplemental reports that the police have essentially written since the original report, because they often will, essentially anything that they do, they create subs.
Right.
And so after last week, just because of all of the discovery issues that we had, I requested that, and I have the following of it. Essentially, it's a continuation. I believe his ends at page 19. This then starts at page 19 and it goes, so I have the rest of that. So I just wanted to make a record that I'm turning these 4 documents over to the defendant based on our last appearance.
And there's an objection. So in regards to that,
There is no regards to that.
There's a continuing duty to disclose.
But you're objecting to her giving you that?
All these months.
Are you objecting to her giving you that?
I'm objecting to what she stated. I'll review what she has. Doesn't make it true, but I'll review it.
And I would like to actually know, I think he actually has all of these because he scored them, and the police department actually told me that he has them. If anything, I didn't have, like, I didn't have the stuff because I hadn't requested it before. So I just wanted to make sure that's very clear in regards to what I had and what I was turning over.
Okay. All right. So I took another opportunity last week to review the pleadings that have been filed on the 404B motions, both plaintiffs or prosecutors and defense. Anything either one of you want to add to your briefs and pleadings? Ms. Wojcicki?
Judge, the only other thing I think that might be relevant, and I don't have the documentation for you, I've been trying to gather it, is it's my understanding that, again, the defendant has essentially filed another PPO against the complainant in Washtenaw County. She is being represented separately for that. That was dismissed again. And it's just to show that continuing pattern of essentially what my motion.
Objection.
What my motion.
You can't object to her argument during a motion.
What my motion addresses, which is this pattern of using certain entities to continue to harass the complainant. There was essentially no foundation for that motion. Again, I don't have the paperwork. I'm trying to get it from the Washtenaw courts, but I do think, just again to add based on what I had previously stated, and this was maybe less than 2 weeks ago, she notified me that this had happened.
Okay.
And I would just like to add, Your Honor.
I didn't ask you.
Oh, okay. Oh,
is there anything you want to add to your written pleadings?
Absolutely. In regards to this complex complaining witness and prosecutor in regards to this matter, that individual, Ms. Santania Green, has contacted me through various modes, which prompt a request for a PPO, because I have rights and I'm going to protect myself. Okay? So we're not going to do gender-based violence.
Okay. You don't have to defend it.
Okay.
She's just letting you know that that's one of the things that's under 404B she's seeking to use against you at trial.
And I'm letting her know.
You don't have to respond to it now because there's the truth or veracity of that is not being decided today.
Yeah.
She's letting you know that's one of the long list of things that she wants to include under 404B. So there's no response necessary to that. My question is, other than what you've submitted on paper as to 404B, both your request and hers, is there anything you'd like to add to your pleadings?
Absolutely. I spoke to it. I'll say it again. Ms. Green, the complaining witness, has contacted me through various modes.
I don't care.
I do.
Well, it doesn't matter what you care. I don't care. I don't need to hear that. Whether or not you had justification for seeking the PPO isn't even on the table today. The truth or untruth of what Ms. Moisisian said is not important right now. What's important is she's letting you know that she wants to include that under 404B.
Yeah, she's just misrepresenting information that's filed upon the court.
Which, once again, according to you. So I'm going to ask one more time, and then I'm not going to let you talk anymore. Is there anything you want to add to your pleadings other than this Washtenaw County PPO thing?
Yes, the complaining witness also had our son place a AirTag tracking device in my vehicle on 12/15, the day of the parenting time exchange from Livonia Police Department. It was then heard and discovered in the vehicle off the minor's person in my vehicle. I then checked his phone because he unlocked it willingly, no issue.
Let me stop you for a minute.
Go ahead.
Are you telling me that because you're letting her know that that's some of the 404B that you want to talk about on the day of trial?
I'm going to add it all in. She's going to hear it all.
Okay. Sure, we'll do it. Yeah, put it together. Yeah. All right. So she's on notice. I'm on notice. Got it. Anything else as to the motion that's up today? Motions that are up today?
Yes. So in regards to that, that is a direct violation and it's a cause for dismissal, a swift dismissal, because it's violating me, it's causing terror, and it's 2 or more non-continuous acts as well.
So even if Ms. Green was standing in front of me right now and admitted doing that, that would not be grounds to dismiss this action.
Well, she already lied in regards to the whole entire 6 allegations.
Which,
but, okay.
You heard what I said, and that had nothing to do with the 404B.
Mhm.
So don't talk anymore because I've given you 3 opportunities and you haven't taken them. So I'm ready to rule on the pleadings. I'm denying all of your 404B motions because the proof is exactly what we just went through today. Under 403, and I'm going to read it because I think the whole damn thing applies to this case. Although relevant, and we can question whether or not all this stuff would be, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Everything I'm hearing from you is almost all of those things, and most of what I'm hearing from you is just going to confuse the hell out of everybody. So we're going to talk about July 18 to August 10 and January 14, and that's all we're going to talk about on the day of trial. We're not getting into anything past, anything beyond that. That range of dates in that January 14th date is all we're going to hear about when the jury's in the building, which is when? January 29th? All right, now, are you still seeking a court-appointed attorney? Because my understanding is they're just waiting for you to fill out some paperwork before they can process that.
Who is that? I don't know who they is.
MIDC.
Oh,
My understanding is you didn't want to fill out the paperwork Ms. Patton asked you to fill out.
she never asked me to fill out anything.
I sent it to him and he did not fill it out, and that's what they need.
Your name is Miss Mortsfield, not Miss Patton. Miss Patton never gave me anything.
Well, did Ms. Mortsfield send you something about a court-appointed
Yes, she
attorney?
did.
Did you fill it out?
I did not.
That's why you don't have an attorney. Have a nice day.
I didn't request one.
Goodbye. January 29th, what time are we scheduled?
8:30.
8:30. If you're not here at 8:30 on the 29th, I will hold you in contempt, and I'll deal with that after the jury trial.
I'll be here at 7:45.
That'll work.
Please ensure that the defendant is not contacting or included.
So what are you doing now? What's your main function?
So I'm doing mostly all sexual assault cases, but the focus is on the untested kids. So sexual assaults from like the late 1990s, early 2000s.
Oh my God. It's got to be.
Yes, I love doing that.
Really? It seems like it'd be so frustrating.
It's the most frustrating. It's so frustrating, but it's also so much more, I guess, interesting. And the investigators that I have are amazing because that's all they do. It's like they're a task force. So anything you need, they will do it for you.
Yeah, and they're all on the top of their game.
Exactly. Very good officers. Like, so the
I'm glad you're
trials
having
though are
fun.
very difficult because there's so many evidentiary issues
Yeah.
with them.
Yeah.
And then I get mad and then I get annoyed that I'm doing these cases and then I go to trial and then I feel better. And so it's like,
Well, I'm glad you're having fun.
yeah, it's at least I'm learning a lot. Things that I never thought
Good.
I'd do.
This exchange highlights a clash between emotion and legal structure. The defendant keeps raising broad claims, but the judge stays focused on what's legally relevant, repeatedly narrowing the discussion. By applying rules like 403 and 404(b), the judge excludes confusing and prejudicial evidence, limits the case to specific facts and dates, and reinforces a key principle: in court, clarity and relevance matter more than emotion or repetition. Thanks.